Hello, everyone, and welcome to the channel, Ontario Law and the Older Person. And I've called it a Battle of the Wills, a court case. So yes, it is a fight over whether or which will was binding. It will be a longer video because we are looking at a court case that's a little longer, even though I've cut out a lot of material. But we also have a shady lawyer and an incompetent judge, so you might find it an interesting thing to listen to. The warning: the information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. This is the name of the case, and I apologize right now. I will be butchering the pronunciation of these names. I have looked it up online. I am trying to keep in mind how to say them properly, but my tongue is just not wrapping the right way, so hopefully no one will be offended. I am making an honest effort. So, Anrup versus Nakvi. That's what the internet says is how you say that name. So it's a 2026 case, actually fairly recent, February 2026, and that little list of letters there, ONCA, that tells us it's an Ontario Court of Appeal case. So in this situation, something has happened where there has been already a court decision made. One side didn't like it, so they appealed it to this level of court. And so this is the decision made by the appeal court. So this is text directly from that decision online. Paragraph 1. Rekha Anrup died on July 4, 2022 at age 89. Acting on Rekha's will, dated October 20th, 2021, which named him executor and trustee, his grandson Brian Anrup began administering Rekha's estate. So in that will, his grandson Brian had the right to make these choices. Paragraph 2. Based on that will, Brian applied for a certificate of appointment of estate trustee pursuant to relevant statute. Brian also applied for and received a life insurance payout of some $21,800 from the Royal Bank of Canada. Paragraph 3, and I'm sorry with this one, Tandrawati Nakvi, and they call her Chandra through the rest of the case, or she's also the respondent, is one of Rekha's 4 surviving children. Chandra objected to the initial application, so the application by Brian, claiming that a later will was Rekha's valid will. Based on the later will, Chandra brought her own application for a certificate of appointment of estate trustee. Paragraph 5. Brian and his mother, Amadai Herdaliel, the appellants, responded to Chandra's application by bringing their own application in which they objected to Chandra's application and challenged the validity of the later will. Rekha's 4 surviving children are named respondents to the application. However, only Chandra participated in this proceeding. The judge writing this decision uses the term application judge to refer to the earlier judge who made the earlier decision. So the first judge made a decision in favor of Chandra, actually, and so Brian and his mom are appealing that decision. So that's what it means when they say application judge, that earlier judge and their decision. So paragraph 7, the application judge declared the will produced by Chandra to be Rekha's valid will and, by judgment dated January 10th, 2025, dismissed the application. That's the application by Brian and his mom. By order dated February 4th, 2025, the application judge ordered the parties to bear their own costs of the application. Paragraph 8. Brian and Amadai appeal against the judgment, and if they are unsuccessful in the appeal, seek leave to appeal against the costs order. Paragraph 9. For the reasons that follow, in my view, so that is the appeal judge, both the judgment and the costs order reflect legal error and must be set aside. Accordingly, I would allow the appeal and award the appellants costs of the application and the appeal. So this judge is reversing what the earlier judge decided. So this means that Brian and Amadai won. An unfortunate trend with a lot of judges writing decisions is they don't necessarily put all the information together in a way that is the most easily understood by readers. So, for example, in this case, this judge sprinkled people's names and relationships to each other throughout many paragraphs. It can be hard to keep track of whom is whom, so that's why I created this little list, cast of characters. Rekha Anrup, who was a testator, died July 4th, 2022. So it's his wills that are being fought over. Then we have Noreen, Reka's son and Brian's father, who died December 30th, 2021. So he died before his father did. Amadai, Noreen's common law spouse and Brian's mother. Brian Anrup, Reka's grandson and executor of Reka's will, dated October 20th, 2021, and in fact other wills as well. Chandra, who is Reka's daughter, executor under the will made May 26, 2022. Then we have Lakshmi, who is Reka's daughter, and then Reka's two other children, Bisram and Ramdat. Sorry. Um, so he has four surviving children. One died before he did. These are my summaries here. This is not straight from the text. So, over time, Amadai became Reka's primary caregiver, which came to include tending to day-to-day needs such as feeding and bathing, managing interactions with healthcare, and providing financial support. Naren did provide some support until he died, so that's the son who died before his father. As did Brian. None of Reka's other children contributed to his care. Lakshmi lived in the house with them, but left all care to the others. And then Chandra had very little interaction with Reka before his death. This is my summary about the wills. So there were actually four wills that were addressed in this case. So the first will was from a will kit, boo, dated February 28th, 2021. The house was to go to Nareen unless he died before Reka, which actually happened, in which case it was to go to Brian. Lakshmi is allowed to stay in the house as long as she wants. The second will was done by a lawyer, dated March 3rd, 2021. Same as above, same conditions and instructions. Third will, by the same lawyer, dated October 20th, 2021. The house was to go to Noreen and Amadai jointly. If both died before Reka, the house was to go to Brian. Lakshmi is allowed to stay in the house as long as she wants. And then we have a fourth will, and this is by a different lawyer, dated May 19th, 2022, and that is one that we're going to give more discussion to. This is again my summary. On March 26, 2022, before the final will was drafted, Reka met with the lawyer who had drafted his previous two wills. He now wanted to transfer ownership of the house to Amadai and Noreen. The lawyer, having found Reka of the capacity to sign the other two wills, was concerned by his behavior in this new appointment and was concerned he had lost that capacity. She asked him to give him written instructions, but found those instructions difficult to understand. She told him she wouldn't proceed until she got a medical opinion about his capacity. She never received any such medical opinion. Now we move on to the fourth will, and this is straight from the text, paragraph 26. It will be recalled that the fourth will is dated May 19th, 2022. It was drafted by, and here is the other lawyer's name, except I'm not using it because this lawyer comes off really badly in this court decision. If you want to get their name, you can go to Canley and look at it yourself, but I will be referring to this lawyer as NN. So NN was a solicitor who practiced primarily in the real estate field, so not an estate lawyer. NN met with Reka twice. First on March 14th, 2022 to obtain instructions, and second on May 19th, 2022 to have the fourth will executed, signed. The fourth will divides the residue of Reka's estate into four equal parts, one for each of Reka's surviving children. It makes no provision for Brian or Amadai. And so I'm saying look at the 2-month gap between meetings, but also, of course, this represents a huge change in beneficiaries. And then from paragraph 27, at the time of NN's interactions with Reka, he was renting office from Chandra's husband, who owned a real estate brokerage and would refer clients to NN. So not exactly a disinterested lawyer in this scenario. Taken from paragraph 28, NN drafted the fourth will for free. He did not complete a reporting letter. In his affidavit filed in this proceeding, NN said that his notes from his two meetings with Reka reflect his view that Reka had testamentary capacity, that Reka understood the nature and extent of his property, was frail but sharp, and understood he was dispossessing Amadei and Brian. NN's perception of Reka on March 14, 2022 stands in stark contrast to the observations made by the original lawyer just 2 days later, noted above. And the original lawyer met with Reka about 6 times as opposed to just two. After all, they drafted two lawyers for Reka, so they knew Reka better. Paragraph 29. The fourth will contains a provision stating that if Reka was still skydiving and had made no fewer than 50 dives in the year immediately preceding this death, the estate was to pay for an ash dive, the skydiving provision. Reka had never skydived in his life. The respondent conceded that this provision was a mistake. The man was in his 80s when he was doing these wills, and where do you get skydiving? I want to know if this lawyer was drafting a number of wills and was mixing up the clients. But also, this tells us that Reka signed off on this will with this skydiving provision. And does that mean that he didn't understand what he was signing, or does it mean he didn't read what he was signing? Right up there, that's a huge red flag. This is again one of my summaries. On May 15, 2022, 7 weeks before Reka died, Amadai and Brian moved out of the house. Their reason for this was that after Noreen had died, the children, aside from Lakshmi, became abusive. The children believed Amadai and Brian had no right to remain in the house and would go to the house to harass and threaten them. The exact nature of the threats isn't described. At one point, Amadai contacted the police to get rid of them, and after that, Bisram and Ramdat stopped going to the house, but the harassment from Chandra continued. And so remember, the fourth will was dated May 19th, 2022. So 4 days after Brian and his mom were driven out. After moving out, Amadrai hired a personal care worker to take care of Reka, concerned that the children wouldn't. And remember, Lakshmi was still living there. So what is this daughter doing? There's no interaction of them participating in any of these situations. So how is that happening? I would have liked to have heard a little more about this person. Paragraph 36. Brian and Amadai were unaware of the fourth will until Chandra opposed the initial application, produced the fourth will, and brought her own application for a certificate of appointment of estate trustee. Prior to this, Brian took steps to administer Reka's estate based on his shared understanding with Amadai that the third will, which named Brian as executor and trustee, was Reka's final will. Paragraph 37. In the application, which is the subject of this appeal, Brian and Amadai objected to Chandra's application and challenged the validity of the fourth will. Brian also brought a motion to have the CCC action dismissed. The motion. We're not going to go into the CC stuff, but SCC stuff. But another issue they touched on, which I did not go into much detail about, is they also claimed that the fourth will was a forgery, that the signatures didn't match up, and they actually brought in a handwriting expert or whatever. But not going into that. So one of the issues that was brought into question, did Rika have the capacity to make the choices that he made under the fourth will? So paragraph 42. The application judge, so the earlier judge, reviewed the medical evidence from the solicitors, and Rika's voice-taped statement in which he stated that Amadai and Brian were to have his house upon his death. She said there was insufficient evidence to ground a finding that Rika did not have capacity to make the fourth will. The medical records did not clearly indicate any cognitive difficulties. She accepted, that's the judge, NN's evidence based on his meeting notes that steps had been taken to ascertain capacity, and concluded that Reka knew the extent of his assets and was aware that Amadai and Brian were not included in the fourth will. And unfortunately, the judgment doesn't talk about what this medical information meant, what kind of records. We don't know the content of NN's notes that he was taking as he was talking to Reka. So there's a lot of missing information here. It's hard to make a judgment about a judgment when we have these missing details, but this is what we've got. Paragraph 43. Amadai and Brian argued that NN was in a conflict of interest because he was a business associate with Chandra's husband Askar, who referred real estate files to him. The application judge found that if there was a conflict of interest, it was overcome by the fact there were no divided loyalties between NN and Reka. They did not know each other prior to their meeting on March 14th, 2022, and there was no evidence that NN was influenced by Chandra and or Asgar. And what do you think about that decision? So the lawyer who wrote the will in favor of his landlord's wife. Yeah, I think there's no divided loyalties there. His loyalties should be purely for Reka. How can he be purely for Reka when his some of his financial livelihood was based on the husband of the woman who would be a beneficiary? Anyways, paragraph 44, the application judge found that the inclusion of the skydiving clause was careless will drafting, but did not displace Reka's understanding of the important dispositive clauses in his will. Then another issue is undue influence. And I go into more detail about what undue influence is in another video, but it's the idea that someone does have the capacity to make their choices, but someone else is putting so much emotional pressure on them, they're making choices they normally wouldn't make. And it usually does involve some form of emotional manipulation or even abuse. So from paragraph 45, the application judge concluded that Reka was not unduly influenced in the making of the fourth will, despite the presence of several of the factors listed in another court case, namely dependency and isolation, recent family conflict and bereavement, and the use of a different lawyer to draft a radically changed will. She found these matters were explicable in the circumstances, so explained by, not as bad as it sounds. Moving on to the rest of that paragraph. Taken straight from the text, Reka was not as frail or dependent as Amadai made him out to be, and while he needed some assistance, he was not entirely dependent on anyone for care. So basically ignoring, oh, by the way, I don't know if I mentioned the three people, his son, his daughter-in-law, and their child, lived with him for 24 years, whereas the others had almost no interaction from them. So the original judge is challenging information provided by the person who cared for him the most. Anyways, there was no evidence Reka was involved in the family conflict, which ended when Brian and Amadai left the house at the time he signed the fourth will. Yeah, they left a few days earlier, and it's kind of crazy to assume that this conflict didn't touch him at all. But anyways, so not part of the conflict. Okay. Reka's grief over his son Nareen's death did not impact his capacity to sign the fourth will. Well, why not? According to Mr. NN, the lawyer, at his meeting with Reka on March 14th, 2022, he asked Reka about the disposition of Amadai and Brian and found out that Reka was mentally sharp and gave instructions, and there was no evidence that Chandra was in the room when the fourth will was being reviewed or signed. And I find this weird phrasing. No evidence she was in the room. Well, the lawyer was there. Why can't he flat out say she wasn't in the room? I just, maybe that's a weird phrasing on the part of this appeal judge's way of doing things. I don't know. But how come we don't know for sure? Okay, so not everyone who asks for an appeal gets one. And it can't be just a matter of, well, I don't like the decision, so I want a different process. You have to raise arguments that suggest an appeal is necessary. So issues that can make a judge's decision subject to appeal: error of fact. The judge didn't have all of the relevant facts or interpreted them incorrectly. Error of law. The judge misapplied the law to those facts. Paragraph 53, where we get the short answer. You don't need to listen to any more than this to find out what happened. As the propounder or supporter of the fourth will, the respondent, Chandra, had the burden of proving it was properly executed and that Reka knew and approved of its contents. The application judge found there were no suspicious circumstances in connection with the fourth will, and consequently, the presumption of validity prevailed. The finding is the result of both legal error and palpable and overriding errors of fact. Thus, it cannot stand. So, this is a huge criticism from the appeal judge to the original judge and their decision making. Paragraph 54. The most critical error the application judge made was her finding that Reka had good reason to make the fourth will and disinherit Brian and Amadai. She made this finding based on the evidence of NN. According to NN, the notes of his meeting with Reka on March 14th, 2022, showed that he asked Reka why he wanted to change his will and leave nothing to Brian and Amadai. And Reka responded Amadai and Brian had treated him really badly after they left the house. The statement. In his cross-examination, NN repeatedly confirmed that his notes were correct, contemporaneous, and verbatim. Paragraph 55. However, the statement does not comport with reality. On March 14, 2022, Reiko was still living in his home with Amadai and Brian, and they were his sole caregivers, doing an unquestionably fine job. Amadai and Brian did not leave Reika's house until May 15, 2022, which was over 2 months after the March 14, 2022 meeting, and they never treated Reika badly. So those dates aren't lining up very well for this argument. Paragraph 56. How then do we explain the statement? There are at least four possibilities. Reka did not make the statement. Reka made the statement but was mistaken in what he said. NN's notes were altered and backdated. That is a huge criticism from the judge to the lawyer who drafted the last will. That's a big deal. And also, is there actual evidence that they were altered and backdated? So that's a big blow. Or NN's notes were fundamentally mistaken. No matter what the explanation, it is clear that the application judge did not appreciate that the purported reason for Reika wanting to enter into the fourth will could not be correct. And then we're moving on to the rest of that paragraph. Consequently, it was a palpable and overriding error for the application judge to find that Reika made the fourth will for good reason. It was palpable because the error was clear. It was overriding because, as the application judge stated, it was central to her finding that the fourth will was valid. So that what this judge is saying is pretty much the basis for the earlier judge's decision that the will was valid is it was done for a good reason. And that good reason has just been undermined. Paragraph 58. As the propounder of the fourth will, the respondent had the onus of proving both that it was properly executed and that the testator knew and approved of its contents. I skipped some stuff. There is a presumption of knowledge and approval, as well as testamentary capacity. However, this presumption is upended when there are suspicious circumstances. And these suspicious circumstances can include surrounding the preparation of the will, calling into question the testator's capacity, or tending to show that the testator's free will was compromised by acts of coercion or fraud. And I skipped some stuff. According to this appeal judge, suspicious circumstances were established, knowledge and approval were not. So paragraph 59, in addition to the application judge's foundational error in finding Reka had good reason to make the fourth will and disinherit Brian and Amadai, there was evidence of three other matters, each of which either amounted to a suspicious circumstance or negative knowledge and approval of the contents of the fourth will, or both. Paragraph 61. The application judge was aware of the foregoing, that Chandra's husband referred clients to NN and therefore gave NN financial benefit, and that NN did not charge Rika for preparing the fourth will, nor did he send Rika a reporting letter. I just want to ask, sometimes people do pro bono work, and it wasn't like there was a huge amount of assets at stake here. I think it was just in one house. So should that be a factor? I mean, yes, the lawyer does seem shady, but I don't know if that should be a strike against that lawyer. Okay, but the fact that they did not send Reka a reporting letter, that's a huge violation of, basic standard practice, I guess. Okay, the application judge stated that one might consider that there was a conflict of interest in NN acting for Reka given that Chandra was married to his landlord and that Asgar referred business to him. Despite this observation, the application judge concluded it was overcome by the fact that there were no divided loyalties between NN and Reka because they did not know each other prior to their meeting on March 14, 2022, and there was no evidence that NN was influenced by Chandra and or Asker. Yeah, This judge we're hearing from didn't like this at all. We'll see that in the next slide. Paragraph 62. This finding reflects clear legal error. A conflict of interest, by definition, results in divided loyalties. The fact that NN and Reka had never met prior to March 14, 2022, is irrelevant to the question of whether NN had divided loyalties by virtue of his relationship with Asger. The application judge did not apply the correct legal principles in determining whether NN was in a conflict of interest in preparing Reka's will. As a consequence, she did not properly consider the matter. The evidence of an apparent conflict of interest was sufficient to satisfy the low burden associated with establishing a suspicious circumstance. So when a person is saying, okay, there's a suspicious circumstance related to the drafting of the will, they don't have to prove a very high case. Uh, it's not a difficult standard to meet. And so here we have a situation where the lawyer drafting the will actually owes something financial to the husband of one of the beneficiaries of the will. So I think it's pretty obvious that that means there's a conflict of interest. If there's a conflict of interest, we have a problem. And then no reliable evidence that Reka knew and approved of the contents of the fourth will. Paragraph 67. Having found suspicious circumstances, the presumption of validity was rebutted. So we've all demonstrated that we can attack the validity of the will. There's a good reason to do so. Consequently, the respondent, which is Chandra, bore the burden of proving that Reka knew and approved of the contents of the fourth will. There was no reliable evidence to support such a finding. Indeed, the evidence is to the contrary. I say this for two reasons. That's the judge. So just the existence of the skydiving clause when Reka had never skydived ever. And then the lawyer and then admitted that he didn't go through the entire will with Reka, just the clauses he thought were important. That excluded the skydiving clause as far as we can tell. So Reka hadn't even read the entire will before he signed it. The appeal judge found the fourth will invalid, but even if the will were valid, it had no suspicious circumstances, for example, an investigation into undue influence was still relevant. So from paragraph 77, indications of undue influence include, so not limited to, but include, and also you don't have to demonstrate everything on this list. So here are some signs. A testator's vulnerability, dependency, or social isolation. So I suspect that there's a lot of evidence that this person, Reka, was vulnerable and dependent. And of course, part of that would be social isolation. And of course, his caretakers were driven out of the house. So I think we have some vulnerability and isolation there. The presence of family conflict and recent bereavement. We have both of those. Questions about the confidentiality and the independence of legal advice. So the lawyer who drafted the final will gets financial benefit from the husband of a person who would be a beneficiary in the will. I suspect you couldn't call that independent legal advice. A substantial departure from previous wills and a lack of explanation for such a departure. So huge departure, change in beneficiary, and allegedly Reka's reason is because his caretakers had been treating him badly. We have no evidence of that, and we're relying on the shady lawyer's notes for this statement, and the judge feels the shady lawyer's notes aren't necessarily reliable. Changes to other legal documents, such as powers of attorney, made simultaneously with testamentary changes, and I don't think we have that in play here. Statements made by the testator, which suggest that their wishes are not accurately reflected in the will. So I didn't touch on this, but he actually made a video where he was saying he wanted his daughter-in-law and grandson to get the house. So we have a clear statement. Now, there was some question as to whether he had capacity when he made that statement, but it's still evidence. So this is paragraph 78. All of these considerations point to undue influence in this case. Reka was an 87-year-old man with several debilitating medical conditions, including a persistent brain hemorrhage and diabetes. At times, he was incontinent, and in the weeks leading up to his first meeting with NN, he fell 4 times. Reka was also very affected by the death of his son Nareen at the end of December 2021. Medical notes indicated that he had lost the will to live. Reka was clearly in a vulnerable state and dependent on others for his care in the period March to May 2022 when the critical events took place. Paragraph 79. There was also clear evidence of family conflict. Reka's videotaped statement shows he was concerned about that conflict and about his other children pressuring Brian and Amadai to leave the family home. The circumstances surrounding Brian and Amadai's departure from their home, described above, show that Reka's concerns in this regard were fully justified. Paragraph 81. The application judge dismissed the presence of family conflict, saying that Brian and Amadai left the house 4 whole days before the fourth will was signed. However, that statement loses sight of why family conflict can be a sign of undue influence. The fact that Brian and Amadei left their home 4 whole days before Reka allegedly signed the fourth will, and they say allegedly because there's some dispute as to whether Reka actually did sign it, does not mean that family conflict played no role in the creation of the fourth will. On the contrary, it is equally suggestive that others may have influenced Reka to cut Brian and Amadai out of his will. The concern is heightened given the caregiving role that Brian and Amadai played in Reka's life because, as a result of Amadai and Brian leaving the home, Reka's support system was removed, leaving him in a more vulnerable state. So think about what this application judge was doing. There was aggressive behavior from these other adult children in the household. They had to call the police to get the brothers to leave them alone. And this application judge seems to think that Reka was somehow distanced from all of this conflict. It's pretty insane thinking. Paragraph 83. The substantial departure in the fourth will from the terms of the first 3 wills, recent in time, meaning, the number of wills, possibly 4, they did occur within a fairly tight timeline, as these things go, also cannot be ignored. The fourth will could hardly have been more different from the previous 3. As explained above, there was no valid explanation for their departure. Brian and Amadai remained in the home with Reka until May 15th, 2022, despite threats and intimidation. Even then, they never abandoned Reka. Rather, Amadai arranged for Reka to be cared for by a personal support worker out of concern that otherwise he would not be properly cared for. And she was probably right. The application judge gave insufficient attention to the fourth will's substantial departure from the terms of the previous 3 wills. Paragraph 84. Finally, there are several events contemporaneous with Reka's first meeting with NN on March 14, 2022, in which Reka allegedly gave NN instructions for the fourth will. These events are clear evidence that the fourth will does not reflect Reka's true wishes, yet the application judge failed to give effect to them. The week before the meeting on March 14, in Reka's voice-taped statement, he states that he wants to leave his home to Brian and Amadai. He refers to bullying and infighting amongst his family and tells Amadai to hang on to records and not let anybody tell them they had to move. Going on, next slide for the rest of the paragraph. 2 days after the initial meeting with NN, Reka went to Ms. Katosh, and she was the original lawyer, and asked her to add Brian and Amadai to title to his home. He gave her handwritten instructions to the same effect. While Ms. Katosh did not act on those instructions because of concerns about Reka's capacity, it is evidence that must be considered when considering the validity of the fourth will which dispossessed Brian and Amadai of their inheritance. All of these matters indicate that Reka's true intention was to ensure that, on his death, Brian and Amadai would receive his home. So, as I mentioned before, Brian and Amadai won this case. The appeal judge threw out what the original judge decided. Okay, look at this scenario. So we have an older man who's fairly vulnerable and dependent on others who did the right things. He created a will to indicate who was to get what and who was to have what kind of power. Yet after the child who was living with him died, we have a second child living with him who seemed completely indifferent to what was happening, wasn't participating in any way, and then the other 3 feeling they could browbeat him into changing his will and drove out his real caregivers and then introduced a shady lawyer. And then In challenging this, they show up in front of a judge whose decision making seems problematic. And as I mentioned in the beginning of the video, not everyone gets an appeal. Most don't. So it's pretty scary how all of these factors can come together to abuse someone and to get your own benefit through this abuse. And all you have to do is end up in front of the wrong judge, and these terrible decisions can stand. So, something to think about and worry about. So, this was a long video. If you got to the end of it, thank you for getting to the end of it, and have a great day.